Just to very briefly introduce the chair, who then will take over. So James Bridgeman is a practicing barrister and chartered arbitrator and certified mediator, and he comes from us from Dublin, and I leave it with that and hand over to James.
Thank you very much. As you've heard, I'm from Ireland, a country with, we're not sure how many people. We've had a recent census, and there were about 6 million, something like that, but a lot of people left over the past few years, and people tend to be coming back. I raised an eyebrow when Mele Topo said that Tonga was the friendliest island in the world. But we let that go in the interest of friendliness. You know. It's a country that with 6 million people, I think we've a lot to learn and a lot from and a lot to give to smaller countries. We have integration, we're EU, ICSID. We're very big fans of UNCITRAL, New York Convention country, and we have a lot of direct foreign investment. We've managed to come back from desolation, from where the World Bank was in, the EU. And one thing, talking about friendliness, we discovered that there are no friends in the money markets, none whatsoever. When you're down and out, you're down and out, and that's it. So you have to you have to paddle your own canoe, which must be very, very difficult for a small country, because we're small enough, but smaller countries again, there are no real friends out there. Their alliances is probably as much you get. That being said, we've gotten great advantages from integration. Where in the EU, it has brought us from an agricultural, undeveloped economy into a modern, developed economy. We had problems with dumping, if you call free money dumping. An awful lot of money came in, unregulated, and then as the tide comes in, the tide goes out. And when the tide goes out, there was nowhere to turn to. And that's basically what happened. We're lucky that we have a very close relationship with our sister country here. We've got very close family relationships, social relationships, and other relationships that has often been a help to us over the years. At the same time, it's a very close relationship, so we were both the colonizer and the colonized. So we have a very unique kind of a perspective in the world of small states. So I'm delighted to be here. It's one of the most interesting and the most exotic conferences that I've ever been to, and I would really like to thank Petra and Eva and Ronson for in allowing me to attend, and I'd like to thank Wilbur Hale for its role in sponsoring this. It's a wonderful 2 days we're having. Dr. David Berry was a speaker on the first panel, and his CV is in your papers. What it doesn't say is that he has an identical twin who performs the same role, and he's on this panel. So the identical twin of Dr. Berry is going to present now, please. Thank you.
I wish I had an identical twin. Then I could be sitting and relaxing in the audience. But thank you for that introduction. Now, we've been kept under very strict time limits for this panel, and so given the shortness of my time, I'm only going to touch on a few topics. I'll provide a brief introduction to the CARICOM single market economy and the Caribbean Court of Justice. And this CSME regime, single market economy, or CSME, sets up something between a customs union and common market, and is being enforced by the Caribbean Court of Justice through its original treaty interpreting jurisdiction. Then I will highlight a couple of current issues which I think might be of interest both within and beyond the Caribbean region. And these are the potentials and limitations of closer cooperation in a context including small and what I would call very small states. And then secondly, the potential of judicial enforcement of CSME rules in a context of limited compliance by member states. And at the end, I'll offer some tentative conclusions. All right, so here's the map again with a little extra square added to it. Member states of the Caribbean community are dispersed throughout the Caribbean, and you can see all of the member states. Does this have a little light on it? No? Okay. Well, anyway, I won't. Most of you have seen this map already, so I won't run through it again. But we extend all the way from Central America, Belize, former British Guyana, all the way up to Bahamas, Jamaica, Haiti, Eastern Caribbean island chain, Trinidad and Tobago, Guyana, and Suriname. 15 member states, and it's governed by the treaty called the Revised Treaty of Chaguaramas. Now, the CARICOM single market and economy sets up, as I've said, something close to, but not quite, a common market structure. Members have removed all impediments to trade between them. They conduct and pursue common external commercial relations, including a common external tariff, and allow free factor mobility in some areas across national member frontiers, including free movement of goods, persons, although this is very limited, free movement of persons, services, and capital, again, limited in the capital area. The goal of the CSME's trade regime is expressed in Article 78, subsection 1 and 2 of the Revised Treaty of Chaguaramas, and I've excerpted them for you. 78.1 reads, the goal of the community trade policy shall be the sustained growth of intra-community and international trade. So notice the two focuses, within the region and internationally, and mutually beneficial exchange of goods and services among the member states and between the community and third states. In fulfillment of this goal, the community shall pursue the following objectives. Full integration of the national markets of all member states of the community into a single, unified, and open market area. Single, unified, and open market area. This is a potentially transformative goal of the CSME and will change the nature of the states of the Caribbean if it is fully implemented. Drilling even further, the scope of community law provides rights related to, as I've said, free movement of goods, services, persons, and capital, including for goods. The revised treaty continues the common external tariff. It's like a common customs tariff in the EU, and prohibits import and export duties and charges of equivalent effect, discriminatory internal taxes, quantitative restrictions, and measures equivalent to quantitative restrictions, subsidies, and dumping. With respect to persons, in addition to some free movement rights for persons, limited, the revised treaty includes a right of establishment. So let me turn to the Caribbean Court of Justice. You'll see the very pretty building there in the bottom right. It's gorgeous with all the flags on the outside. Now the Caribbean Court of Justice oversees the CSME. It was created by the agreement establishing the Caribbean Court of Justice in February 2001, and the reason I slipped is the date, February 14th, 2001. What a wonderful date. And entered into force on July 23rd, 2002. The court inaugurated or opened for cases in 2005, and its first case was filed in that year. It's vested with two forms of jurisdiction, and this is fairly unusual, although there is another model. The Eastern Caribbean the Eastern Caribbean Court of Appeal also has the same double jurisdictional role. So the CCJ serves as the final appellate court, and so that replaces, as we heard earlier, the Judicial Committee of the Privy Council, and it would be similar to the U.S. Supreme Court or the Supreme Court of Canada. And that's currently for Barbados, Belize, Dominica, and Guyana. It's hoped that other states will join soon. As a treaty interpreting court, it serves in its original jurisdiction, and it's an international legal tribunal. So the same judges, they go to the same rooms. They don't even cross the hall. They go to the same rooms, and they interpret and apply the revised Treaty of Chaguaramas. And in this function, they're very similar to the European Court of Justice. And in fact, you will see in the cases of the CCJ, tremendous awareness of the jurisprudence of the European Court of Justice. So who are the original jurisdiction states? Almost all CARICOM member states are subject to this treaty enforcing jurisdiction. And you can see the list: Antigua and Barbuda, Barbados, Belize, Dominica, Grenada, Guyana, Jamaica, St. Kitts and Nevis, St. Lucia, St. Vincent and the Grenadines, Suriname, and Trinidad and Tobago. Now the potentials: the Bahamas is a member state of the Caribbean community by means of a special bilateral treaty. And the same with Montserrat by means of a bilateral treaty. They have not yet ratified the revised Treaty of Chaguaramas, which is the CSME treaty. So they're not yet subject to the original jurisdiction of the CCJ. And Haiti has ratified the revised treaty, but it has excluded full application of the single market to itself because of its current constraints. All right, so what is the nature of the court's original jurisdiction? Why is it original? What is it like? Well, it's original because a litigant can go directly to the Caribbean Court of Justice. You do not have to stop anywhere else, and you do not require a prior hearing before a national court. It's exclusive. Only the Caribbean Court of Justice can interpret and apply the revised Treaty of Chaguaramas. And this gives rise to very interesting implications because, as you would know, in European Union law, national courts can apply EU law that has direct effect. We cannot do that, at least for now, in the Caribbean. It's compulsory. States cannot choose whether or not to appear before the court. If they do not show up, a default judgment will be issued against them, and it's final. There is no appeal. There is no higher court. Now, who can appear before the court? Locus standi. Member states. So a member state can bring a claim against another member state for free trade rights, or the community itself, CARICOM, can bring a case against a member state, or vice versa. And national courts, the referral jurisdiction, which is like the preliminary reference procedure of the EU, and then persons, both natural persons, and we have a case, a young woman, Shanique Myrie, brought a case in her own right, and juridical persons. We have several cases, Trinidad Cement, a company bringing a case before the court. The jurisprudence of the CCJ in its original jurisdiction, even though limited to 8 cases, and I've put them on the PowerPoint for you there, has been very exciting. And the first point of interest to note is that all of the original jurisdiction cases to date have been brought by persons, legal persons, companies, and natural persons. Now, I confess, I got this one wrong. For years, I was predicting my students that nothing would come of this provision, Article 222, because there is a 4-step process by which jurisdiction is allowed. And I thought no one could overcome these 4 hurdles. But these hurdles have been very low hurdles in reality, even though in my mind they were very large. So I'm delighted to see that persons have been able to go directly to the court and have done so in all of these cases. Now, these cases have involved a variety of legal issues, including breaches of the requirements of CARICOM member states to impose a common external tariff on non-community origin goods. One case, for example, cement from Venezuela, flour from the Netherlands. They have involved breach of decisions of community organs, and they have required member states to provide free movement, including hassle-free travel and automatic entry and stay for community nationals for 6 months. And they have also required states not to impose charges of equivalent effects to custom duties on community origin goods. Now, I'd like to highlight that the ability of persons, juridical or natural, to directly petition a court for enforcement of free trade rules is, of course, not common globally. And it's a very welcome development in the Caribbean, since it allows those actors who are most affected by treaty breaches to enforce the treaty themselves. And to some extent, you might say it democratizes regional integration. It allows those who have been affected to bring cases in their own right. All right, so this brings me to my 2 issues. These are controversial issues. And so if I was giving this presentation in the Caribbean, there might be some hot questions from the floor. I encourage you to ask similar hot questions. But the 2 current topics I'd like to deal with, the first is that of closer cooperation. Now, like many regional organizations, CARICOM is plagued by disunity. States continue to assert their sovereignty and refuse to fully implement community law in many instances. But some states want to move forward more quickly than other states. So, for example, the Organization of Eastern Caribbean States wants to implement a fuller version of free movement of persons. This is historical. The OECS states are all within easy sailing distance of one another. Their nationals have moved freely amongst those countries, and most OECS nationals will have relatives in other states. And so it is a large kind of community where that kind of free movement could exist. In CARICOM, free movement is limited to free movement of CARICOM skilled nationals. So you have to fit this very careful test, and then free movement has to be applied for. It's not automatic. The OECS wants to go beyond this. So my questions are, how can this be achieved, and could the EU model of enhanced cooperation work? Is there an inherent limitation for such a model based upon the size for inclusion in cooperative regimes? What do I mean here? what I'd like to do is highlight the geographical and economic realities of very small states. If the states of the Organization of Eastern Caribbean States, most of which have less than 100,000 people, wanted to increase the level of free movement of persons within their jurisdictions, this would be manageable. Similar size states, the movement wouldn't be too significant. But what if, as under the EU's enhanced cooperation regime, this free movement was extended on a reciprocal basis to other states which wished to join the regime, larger states in the region? The number of potential persons who could travel from Jamaica or Trinidad could overwhelm a small state like St. Kitts and Nevis, which has a population of 52,000 persons. And it will be interesting to see, because this is all subject to negotiation now, what model or models can be adopted to allow CARICOM member states that wish to integrate more closely and more quickly to do so within the difficult constraints faced by these very small states. So the question then I pose to you is, how can some states cooperate more closely but without complete equality of obligations, which we would have within the EU system? The second issue, again topical, is judicial enforcement. CARICOM member states have gone some way to implement their obligations under the revised Treaty of Chaguaramas. They have all passed CARICOM acts. We have to transform our treaties into domestic law for them to have effect in domestic law. And so the revised treaty has been transformed in all CARICOM member states, but few other changes have been made. This is where a recent case, Maurice Tomlinson against Trinidad and Tobago and Belize, shows the limitations of allowing self-implementation of treaty obligations by states. Trinidad and Tobago and Belize have on their books laws which, although they are not enforced in practice, appear, at least prima facie, to violate the revised Treaty of Chaguaramas. Now, the CCJ is currently deciding. From authoritative sources, I understand the decision will be out soon, not tomorrow probably, but soon. The CCJ will have to decide whether, one, to continue to permit enforcement through administrative procedures, which it has signaled in its earlier decisions, that it doesn't matter if there's a law that's contradicting a treaty on your books, as long as you disapply it or administratively implement procedures that allow the state to comply with its treaty obligations. Or the CCJ could require congruence between all national laws and the revised Treaty of Chaguaramas. And that, of course, is more familiar to us. If you are ratifying a treaty, you should first change all your laws and then ratify the treaty so that there is no conflict. Now, this judgment, Maurice Tomlinson, one of my former students, I'm proud to say, has brought this path-breaking case to the CCJ, and this judgment will have tremendous consequences for Caribbean regional integration, regardless of which way it's decided. All right, this brings me to flagrantly self-promote and then also offer some conclusions. So that's my book. Let me summarize and offer some conclusions. First, regional economic integration is progressing well in the Caribbean, with 2 regional organizations developing and attempting to enforce their free trade rules between themselves. Secondly, there is a need for a mechanism that will allow small groupings of states to integrate more quickly than others, but the existing mechanisms, like the EU model, may not be suitable. Thirdly, we have reached the stage in the Caribbean where implementation of treaty obligations has to be tightened. How this is to be done remains to be seen. Finally, I remain optimistic about regional integration and the ability of the CCJ to strengthen it. And I would end by saying that it is an exciting time in the Caribbean. It's always exciting in the Caribbean, but even more so now. And it's a new era in Caribbean regional jurisprudence. And the CCJ has heard or is hearing 8 substantive cases. These cases, I haven't had time to discuss them. These cases are path-breaking. We have had our Van Gendenloos decisions. We've had our Ratty decisions. We've had all of these decisions already. They're very exciting. They haven't quite gone as far as the EU cases, but ECJ cases. But we are seeing the framework has been laid. That's as much as I'll say there. And it's heard a number of appellate jurisdiction cases. And these cases have been quite well received. Occasionally you'll have a controversial case, but quite well received, and some internationally well received. There are a couple of arbitration cases involving Belize that have been heralded as prime model examples of national court treatment of public policy, public interest exceptions to enforcement of arbitral awards. So given the publicity of recent cases and the likely effect of any decision in Tomlinson, the court's workload may soon increase. There is a justice of the CCJ amongst us. I'm warning him his workload may increase. But it will also give it and give us further opportunities to clarify and develop Caribbean integration law. Thank you.
I think we'll hold questions till the end. If I think it's probably the best way to go.